and the focus does remain on the Bloemfontein Magistrates Court this morning, where ANC Secretary General ENSAfrica will be formally charged for fraud and corruption relating to the Free State asbestos tender. Now, while many believe the tide is turning in the fight against corruption or alleged corruption, the NPA must now prove the guilt of those involved beyond a reasonable doubt. The issue of witnesses with direct knowledge of certain relevant events might also be a challenge. Another possible obstacle could be that the plaintiffs could plead ignorance and argue that they did not directly benefit. Now, our next guest is an expert at prosecuting white-collar crime. Stephen Powell is head of forensics at legal firm ENSAfrica and joins us now from Cape Town. Stephen, I don't think I'm pronouncing your firm's name correctly. Is it ENSAfrica?
It is ENSAfrica.
Right.
Thanks, Michelle.
Thanks very much again for your time this morning. Good morning. You know, when we think about the story of ENSAfrica, it is one that has been unfolding over the past few years. In your experience in cases with white-collar crime, how much forensic knowledge is needed on both sides of the courtroom, both the prosecution and for the defense, in whatever case you're dealing with?
I think it starts with the prosecution and the investigation, Michelle, and it is a lengthy and difficult process because one has to gather shreds of evidence, and it's like putting this enormous jigsaw puzzle together and finding the shreds of evidence and trying to determine how these link to each other. And with white-collar crime, invariably the state has to follow a money trail, which means that it's got to subpoena multiple bank accounts of third-party entities that may have been responsible for making payments. They've got to identify source documents and then subpoena those. And then in addition, there's a whole digital process that takes place where emails are extracted from servers and devices are imaged, and that all needs to be analyzed. And there'll be multiple devices, there'll be multiple witnesses. In addition, there'll be cell phones with WhatsApp communications. And the challenge for the NPA is to bring all of this together, to find the links in the various pieces of evidence, coupled to interviews that they will have conducted with a multiplicity of witnesses. And once they've put the story together, then they will enroll the matter for prosecution. And it appears from the latest developments that the state is getting close to that point. And then we go into the second phase, and that is where the defense will be entitled to prepare their defense, and they will, once the charges are issued, they will be asking for full disclosure of whatever evidence the state has managed to find, and it will take many months before the defense attorneys are ready to proceed. So you're right, it is a difficult process on both sides of the courtroom.
Yeah, and I mean, it's not just, from what you're saying, it sounds like it's not just the fact that I need to be well versed in the law. I most likely, especially as it relates to white-collar crime, I need to be well versed and almost an expert on financial flows.
Absolutely, and that's the challenge with white-collar crime, because these flows are very easy for crooks to conceal and very difficult for the state to piece together. So typically what the state relies on is for one of the pawns in the game, one of the smaller players, to capitulate and admit what was happening, and if there were illicit instructions, that person can apply for indemnity. We talk about Section 204 of the Criminal Procedure Act, where they can potentially be granted immunity against prosecution in exchange for providing evidence, and we use the term turning state witness. And that's one of the strategies that the state can adopt to try and unravel a complex and difficult investigation, because one of the challenges always is to identify evidence linking the key orchestrators or the kingpins to the activities, because often they may be part of the planning, they may issue instructions. A lot of those instructions are purely verbal, it's not documented anywhere, and it becomes really immensely difficult to prove.
Yeah, and I mean, you know, for me, it's just as simple as, you know, if you've received money in your bank account and it's come from a particular person who also happened to get a particular government tender, that the connection is quite simple there. But as you say, it's not, because a lot of these discussions don't take place over email. A lot of this money is not paid into a bank account.
Absolutely, and it would be very foolish of the individuals concerned to take money directly. So often the money is channeled to third parties via third parties, and there's a number of layers and levels that have to be determined and investigated to see whether there is a potential link. But of course, our corruption legislation, Section 3 of the Corruption Act, doesn't require the state to prove the direct link. It'll be enough if the state can prove that individuals exerted influence over others, and if there is gratification or benefit to a third party that the state can link to that individual, that will be sufficient to prove the gratification. And that entails, whether it is direct personal benefit or whether it's benefit for political parties, paying expenses for political parties. We don't know what the exact evidence is, and it'll be interesting to see as this unfolds how strong the direct nexus is that the state has been able to prove.
In terms of the witness evidence, let's call it, that the state might be able to bring to a case like this, or a case, if we speak in general terms, of white-collar crime, how does the defense approach that issue around a witness who testifies about intricate knowledge of events that transpired? Let's say the issue of Shabir Sheikh, for example, and his personal secretary testifies about what she saw unfolding. How does the defense then unpack that kind of testimony?
The defense will attack the credibility of that witness. Make no mistake, there will be a blunt denial, and whatever negative, adverse information that the defense may be able to establish against that particular witness will be hauled before the court, and they will do their utmost to show that that particular witness is not credible, the evidence is not reliable, and they will use the fact that it will be the word of the individual against the word of the accused, and it is difficult in those circumstances. So what the state typically tries to do is have some direct evidence, so direct witnesses like a secretary who may have been instructed to instruct payments to third parties. That will be very useful if the state has that type of evidence available to it. But then there will also be indirect evidence where the state will be asking the court to draw an inference. So, for example, if there's funding for rallies that benefit the particular accused, and it has obvious direct benefit to a political campaign, etc., the words of the witness, the direct evidence of the witness, will be taken into consideration with those ancillary aspects, and the state will be urging the court to draw an inference based on the evidence placed before the court.
Stephen, in your experience, is a case involving, the illegal spending of money, in the case of a government tender, is it easier to prove that there was corruption if money was paid in a government tender? In the case of this asbestos tender in the Free State of 255 million rand, we know that none of the asbestos has been removed from the homes in that province. Is it easier to prove a case like that compared to corporate South Africa?
I think it's challenging, Michelle, to prove corruption either corporate or in the private sector. The main difficulty really is finding evidence that links the key accused to the activities that are performed by various underlings. Very often, people will blame officials for absolute incompetence, negligence, and they will divorce themselves and distance themselves from any instruction, any mandate, any connection. And the challenge is really for the state to find that link that is inextricable.
Very interesting indeed. Stephen, thank you very much for your time this morning, just giving us the sort of legal aspects of how things do unfold when it comes to prosecuting particularly white-collar crime. Stephen Powell is head of forensic at legal firm ENSAfrica, joining us there from Cape Town. Thank you very much indeed.